So I think I've got an hour and 30 minutes in the program on Friday afternoon. And I have taught my classes before at St. Thomas, and they're long, they're 3 hours in the evenings. And by the first hour and 20 minutes, lots of head nodding going on. So hopefully you've had lots of chocolate.
I have a question.
Yes? All right, you can leave the room. So I might shrink it back to about an hour and ask questions so we can all stay awake and enliven the presentation and improve it with your input. So I'm talking about two topics this afternoon. One on collaborative research agreements and intellectual property. And I guess in this room, we've got mostly researchers, I understand. And how many of you have worked or done research under a collaborative research agreement with an industry sponsorship? So maybe a few of you. Okay. And Catherine, presumably you have under the NCE program. There would be that
I've
sort of
been on the edge.
And what about sponsors of collaborative research programs? Christian, you would have been at NRC, and William, you do that. So a few sponsors, IBM does lots of that. So I'm going to talk about IP in those contexts. I guess there's a number of students here who haven't done that sort of work, and this will be sort of new to you, presumably. I'll talk about approaches in Canada and the US and the UK and the norms in doing these kinds of things in Canada. And then I'll talk about just a few broad comments about the Mobile First Collaborative Research Agreement and what the draft document talks about. I won't go into great detail about it because it's still in draft form and really it's an agreement amongst partners, but I'll talk about sort of just some general points about that. And then I'll switch gears and talk about statements of work. And this might be more interesting. I'm going to talk about sort of changing ideas of research and development, and it ties into my area of research that I did in my dissertation, and why that's relevant to the work that you're doing now. And I'll talk about another field of research, making myoelectric hands, and some of the things that I think are relevant from that research for the work that you're doing. And then I'll talk a little bit about sort of framing those statements of work in milestone and deliverable statements. So for those who don't know, collaborative research agreements or sponsored consortium agreements have a number of elements to them, and I've just enumerated them here. Basically, they set out sort of what work that you're doing. It'll describe the team that's doing it, the PI. It'll talk about the outcome of it, which is typically reports. Maybe there's prototypes or some result that comes out of it, but often it's just information that results from research work. It talks about finances, confidentiality. So your agreement, the Mobile First Agreement, talks about confidentiality and the importance of keeping quiet about any confidential information disclosed to a researcher by a company, for instance. But it balances it with publication rights, the right to publish the research results that come out of the projects that you work on, and especially for students, the right to defend theses and have that disclosed in the public domain. I'll talk about the intellectual property and the grant of rights provisions that are in these agreements and how they differ sort of by jurisdiction. So I'll go into a little bit of detail about that. Term and termination, sort of how things get wound up. Disclaimer of warranty. So unlike typical commercial contracts, there aren't warranties in these agreements. There's usually sort of disclaimers of warranties. And the concept is that unlike a typical commercial transaction where you've got some sort of goods being given to someone in exchange for payment, in these arrangements you've got research work being done, or maybe design work. You don't really know what the outcome of that work's going to be, because it's research. Right? All that really comes out of it typically is information. And so at the heart of these arrangements are just the opposite of a commercial arrangement. It's something where you can't really promise much of anything other than you'll do what you said you would do in the statement of work. The biggest issue often with these arrangements is the statement of work and deliverables, and getting sort of an understanding on what it is you're going to be doing. And even though often it's the IP section that people worry about the most and spend the most time trying to draft, it's often just the simple description of what you're going to do and deliver that is often the most sort of difficult, and the one that leads to most of the disputes in research contracts amongst the parties. So I'll talk a fair bit about that. So what is intellectual property? Patents, copyright, trademarks, trade secrets, other forms of IP, they're all forms of intellectual property. Patents, you all know that there's typically a a 20-year period that patents are granted for, and they're for inventive work. And there's a 3-part test to get a patent. It has to be new, useful, and non-obvious. You pass that test and you pay $20 or $30 or $40,000, you can have a patent issued for your invention. And it's an international system. In Canada and most jurisdictions, it lasts for 20 years from the date of filing. So one form of IP that typically is addressed in these collaborative research agreements. Maybe more relevant to the work that you do is the copyright, which, unlike patents, it arises automatically. So any notes you made today, you'd have copyright in yourselves in that note, in the notes that you would write, or code that you would write. That would be protected by copyright. And unlike patents, you have to apply for it, go through a government process, and it lasts a lot longer. It's typically 50 years from the death of the author. So in some product, some research product you would develop, there may be patents in an algorithm or some invention, and you can go through an expensive process to seek protection for that. But copyright would exist in it automatically. And depending on the institutional IP policy, the college would own it, or the university would own it, or maybe your institution grants you the right to own it, and you as a researcher or a student would have rights in that work. It varies depending on the institutional IP policies. As opposed to typically with companies, the company will typically own the IP that gets developed in the course of the work of the parties. Trademarks usually aren't relevant in collaborative research agreements, but it's different from IP. It's kind of combines elements from both patent and copyrights, and that you have to go through a government process to apply and get rights to the trademark, but it can be a much longer term than 20 years. You can hold them in perpetuity. So you can have trademarks that last forever under 15-year renewable periods, and often can become more valuable than the patents and the technology they were initially designed to protect. Trade secrets. So there may be trade secrets in the work that gets done in this research program, and there's sometimes a debate amongst sponsoring partners on how to protect it. You take sort of the public approach and try and protect it by way of patents, in which case you disclose to the world what the invention is, and in return the government grants you a 20-year right to exclude others to practice that invention. Or you just keep quiet about what the work is. You just don't disclose it, and you don't incur any costs in doing it, you don't disclose it to the world, you don't risk someone else taking that work and exploiting it, but the risk is that someone else might try and patent the algorithm or the invention that you conceptualized. Often sort of a big issue with, especially when you've got smaller companies involved in sponsoring research projects. And other forms of IP. So there are other forms of IP, confidential information, personal information, but typically other than confidential information, which is similar to trade secrets, not a big issue for sponsored research projects. So those are the forms of IP that we talk about when we talk about IP clauses in collaborative research agreements. And I'm just going to mention, for those who don't know, lots of information on all of these topics on public websites. This is the Canadian Intellectual Property Office website. We've got lots of information and booklets on all of these topics. This one here is the U.S. Patent Office website. We've got a couple of sections in the patent section for searching issued patents and published applications. And it would be sort of a very typical, first step in scoping on a research program to do not just academic literature searches, but also some prior art patent searches, just to see sort of what's out there. And in terms of this room, who has done prior art patent searches? Anyone done? A few of you have done it. I'm not sure how relevant it is sort of in your space, but in our area, industrial gas technology, it's just sort of a typical first step that we would take before developing a research program, to see in the academic literature, and then second in the patent literature, who's done stuff before, and what can we learn from that prior work. So I'll just say a couple of words about searching. So it's very simple. This is the USPTO website search engine for, I think, issued patents, and we were doing a search, this was about 7 years ago, on truck fleet optimization for line haul trucking, involving a CRA at UNB, Collaborative Research Agreement. And it brought back a number of patents that we found. So we searched those patents to see sort of what they disclosed, downloaded PDFs, searched back and forth. One of the things about this system is like other systems, you can find references within patents and go backwards in time or forwards in time and find out sort of who's doing useful stuff. And you find sort of a patent that looks similar to yours, provides you sort of a point of movement backwards and forwards in time to see what the useful prior art is. I'd encourage you to do this as part of sort of your scoping exercises for industry-sponsored projects. So that's a little bit about IP. Now I'm going to talk about the approach to IP in different jurisdictions, and I'll start with the US and then talk about the UK and then Canada. And in the US, they've got a legal basis for the approach that they take in higher education intellectual property, and it comes out of an act they passed in 1980 called the Bayh-Dole Act, and it was something that was just sort of slipped into a piece of law that was enacted just before Carter left office, and it basically had a number of principles that it talked about. One is to try and use the patent system to support the exploitation of federally sponsored research work. And they wanted to encourage it, they wanted to particularly encourage small business to benefit from federally sponsored research and its commercial exploitation. And they wanted to take steps to ensure that the work becomes commercialized and publicly available in the US by US labor and industry. And that was sort of the framework that was put in the Bayh-Dole Act. And what it meant was that the US universities couldn't give ownership to IP to companies, but they had to own it and manage it. This is the sort of core concept. And so what it meant is that those sort of leaders in intellectual property management and tech transfer, like MIT and University of Wisconsin and other places, sort of spread the approach that they took on IP management to all the other universities in the US, colleges, and got them all involved in patenting and licensing and commercializing early stage inventions coming out of federally sponsored research work. And depending on who you talk to, it was sort of a highly influential internationally and also sort of a big deal for the US. So this is an Economist article that came out in 2002 that talked about innovation's golden goose, that the Bayh-Dole Act was responsible for. In this article, the sort of turnaround in the US that happened, they argue, from the 1970s to the present, and call it, more than anything else, this single policy measure helped to reverse America's precipitous slide into industrial irrelevance, which seems totally bogus to me. I don't think that it was a piece of legislation that sort of played such a large role. Undoubtedly, like with any change, there was lots of factors at play, economic and cultural and social. But nevertheless, it sort of looms large in the U.S. imagination, this piece of legislation. And I think it is the case that it has had influence elsewhere around the world, in particular in Canada. And so this is just some data on what U.S. licensing income looked like in 2012, sort of as more institutions have got involved in commercializing university and college inventions. So it's, depending on your perspective, it's either a very small number or a very big number in terms of the total licensing income that U.S. universities and colleges received in 2012 from licensing inventions. So $2.6 billion in income. A small fraction of the research budget, but it's maybe about 5% of the total research spending in U.S. universities. And so the approach that you see in terms of how universities handle IP in the United States is exemplified by MIT, for example. So MIT says that typically we own the results of research work done at MIT, and that's that. There's no granting of ownership rights to industry or anyone else. And we will manage it and we will license it. Typically we'll license it not exclusively for exploitation, and we'll look to Massachusetts companies first, and then New England companies, and then U.S. companies. Very rarely would they license it outside of the U.S. And they would typically look for some sort of financial consideration. So they'd look for royalties or some other income stream in exchange for the grant of that license. Right? And they're typical of the U.S. approach to how IP gets commercialized. Now this is just the IP policy. If you look at the programs and all the things that U.S. institutions do to support the development and translation and commercialization of research, there's hundreds of programs. I'm just talking about sort of the institutional approach to IP and how they manage the IP. In the UK, they don't have, like the US, a legislative framework for governing how sort of IP gets handled. Instead, they, like Canada, just have individual institutional policies. And the big discussion that happened that sort of developed the framework for handling IP in the UK was a review that this Lambert Commission did back in 2003. And they looked at, the question was, why are we, unlike the Americans, so ineffective at sort of exploiting and developing our university-based research work? And they had a big study and they produced a big report. And one of the outcomes was a suggestion that maybe we should develop a suite of contracts, collaborative research agreements, that could be used by UK institutions to engage with industry. So there aren't all these fights that will continue to happen over sort of IP and statements of work and budgets and all that sort of stuff. So they formed a committee, they engaged some law firms, and they drafted a number of model agreements. And the approach that they came out with was different than the US approach. It wasn't sort of the institutional ownership approach to IP. It was a little bit more flexible, which contemplated either company ownership of IP or university ownership of IP. And if it was university ownership of IP, there was three options. One where there's granting of non-exclusive licensing rights, and another two where there's just negotiation rights. And then there was the two company model options, one where there's a university right to use for non-commercial purposes, and another option where there is no publication rights, which was kind of startling given the university's mission to disseminate research results. I did some interviews and research on this approach in the UK, and most of the colleagues at UK institutions, universities mostly, said, yeah, this is pretty much the approach that we take in the UK. That we're sort of, unlike the Americans, a lot more flexible in how we handle IP in our agreements, and it'll depend on the context. And these Lambert model agreements that were published and put on websites in the UK, they're the ones that we typically use in structuring our sponsored research programs. And with it came also a guide and some questions that were to be used by universities and companies in developing these agreements. And the guides were sort of intended to sort of take you in the direction of one form of contract or another. So in general, it would ask things like, is this work largely sort of conceived of and developed by a university or college research group? Is it largely funded by public bodies, in which case we lean on sort of university or ownership? Or is this something where a company has come and they're paying all of the costs, overhead costs, everything else, and this is really sort of incidental to the primary research agenda of the principal investigator, in which case maybe this is more like sort of a company ownership type scenario. Yeah? So that's the approach that they took in the UK to that. In Canada, maybe a bit like what Catherine was saying with the communication policy and wireless policy, there really isn't one in Canada. The last big sort of initiative that happened was in the 80s, when they went through a similar process as they did in the UK and had a group of people meeting to discuss sort of why is it that Canadian universities are so ineffective in managing relationships with companies, and what can we do to sort of improve things. And like the experience in the UK 20 years into the future, in the mid-'80s they said, it must be research contracts are frustrating things, and we should develop a suite of model agreements that companies and universities can use to better allow them to engage and avoid bun fights over IP clauses. And they also struck a committee to draft a bunch of model contracts, and like the UK model, they had a couple of options. The company, the option where the deliverables and IP are owned by the company, and the university retains just certain rights, the rights to a research and educational license, so to use it in-house and continue to develop it. And in the event that there's something commercial that came out of it, there'd be a reasonable royalty negotiated in keeping with industry norms. And if there wasn't any exploitation of the results, the IP could be reassigned to the university at some future point. And that was one concept. It's interesting to sort of look at those terms. They're very vague and very general, and the trend in drafting of contracts is they become much more detailed and specific over the last 20, 30 years. The sort of clubby atmosphere of patent attorneys in the 60s and 70s and 80s has sort of given way to much more precise and detailed drafting. This language would never survive now, but it was. You still see it floating around in some universities, even today, the chef model agreements. The other option was the option where the deliverables are owned by the company. So the report, typically the report, maybe there's some prototype that comes out of the research program, gets kept by the company in this deal, and all the IP in that piece of work is retained by the university. That was the other sort of model that they had for how sort of IP would be handled. And like the sort of US buy-dole approach, the university grants some sort of license to the company, or some sort of right of first refusal to exploit the results. And that was the approach that was outlined in that case, or in that series of model agreements. What happened in Canada is, I think largely it was influenced highly by the US approach. And so if you go to most colleges or universities across the country and you ask to work out some sort of sponsored arrangement, sponsored research consortium agreement, they'll typically look to sort of a US-based approach where they'll own the IP, they, the university, and rights will be granted to the company to exploit the results. And only recently has things begun to sort of go back to that kind of older Canadian approach where there's more flexibility for structuring the deal. And in part that's come out of discussions at the NSERC and the Tri-Councils who softened their IP policy, which in the past required university or professor ownership of the IP in projects where they received some of their funding. Now I think they allow more options. It doesn't just have to be that approach. So typically, that's IP ownership. In Canada, typically you'll have students, postdocs, university faculty, and others free to disseminate research results as one of the sort of typical things you see in all collaborative research agreements. Given the university mission of teaching research and service and dissemination of research results, typically this gets included in any contract that gets struck with industry, including in the Mobile First Agreement. There's a clause on this in that agreement. There's usually a clause about, or a series of clauses about striking a balance between protecting IP and delays in disseminating research results. So with patenting, if you disclose something publicly, it invalidates patent rights in most jurisdictions around the world. So if you want a patent, you have to keep secret for some period of time the results of the design work or the research work. And that means that these clauses try and strike this balance between sort of allowing for some period of time to patent something and then afterwards allowing for the results to become public. The concept being that you've got to the patent office, and the day you've got to the patent office and filed your patent, you can then make public your invention, and it's not going to cause any problems with your patent rights. If instead you disclose it publicly to the world, or even disclose it in a seminar room where there's no protection, there's no expectation of confidentiality, your patent rights are lost at that moment, except for a few jurisdictions that allow for a 1-year grace period. So most agreements have some sort of line that allows for sort of disclosure period, and afterwards it's free game on publication and presentation of results. I've talked a little bit about confidentiality provisions that they'll again sort of draw a line between information that's disclosed that by a company that is kept quiet because the company wishes to be kept quiet and it's confidential to them, and the results of the research work that arise from the research group, which would typically be publishable and really disclosable. Yes?
Canada is one of the jurisdictions with a 1-year grace period, is it?
It is. Yeah, Canada and the US and a few others. That's right. Yeah.
So if we disclose in Canada or the US, we have 1 year before we have to file a patent.
Yeah, that's right. Yeah, yeah. But in Europe, those rights would disappear. Conventionally, you have a distinction between background and foreground IP. So foreground IP would be that work that's developed during the term of the agreement, typically with project funding, and that's within the statement of work. That's the foreground IP. The background IP would be all the stuff that's developed before that predates the start date of the program, or whatever that would be. If collaborative work, typically distinguished between sponsor IP, university IP, or college IP, and jointly developed IP. And the typical deal is that the company owns what they develop, or the sponsors or each collaborator owns what they develop solely, and the jointly work is developed jointly. And that's the approach is taken because people frown upon joint ownership, because it's kind of messy. It's like sort of jointly owning a house with a series of people. It's difficult to sort of, if you want to sell it, what happens, and if you have to sort of all agree on how to handle patenting and licensing. Typically, the wish is to have it vested all within one party. There's often a distinction made in these agreements between ownership and the right to exploit. Ownership right being the right to patent something, the right to exploit being typically granted under a license. Royalty rates and research agreements are typically rare, but sometimes they get pre-negotiated to try and avoid working out those terms afterwards. So instead, often what's included is some sort of license to, or option to negotiate a license, or some sort of right of first refusal, or at most some sort of agreement in principle on what the financial terms would be. But where you do get into the financial discussions, there's a number of ways to price IP. The general principle is based on something called the 25% rule of thumb, which says that 25% of the profit from a venture would typically go back to the technology developer. So if you, for example, have a cost of goods sold of something of $8 and you sell it for 10, and you've got $2 of profit, then 50 cents would go back to the developer as under the 25% rule of thumb. Okay? And that's something that came out of a series of research projects in the 60s to look at what's the typical share that goes back to a development team from a piece of IP, whether it's drugs or energy products or software, whatever. And the number it varied by industry, but typically it was about 25% of the profit would go back to the development team. Yes?
Question. What if the research project is improving an existing product? Would that then be subject, because we're not selling it because of that,
Yeah.
would it typically be subject to this 25% of the full product?
No, it would be 25% of the difference between what a product that didn't have that improvement would have as its revenue or its profit. So you'd only get that fraction of additional revenue that would be attributable to that other product. So you don't overprice the value of the research work. And you can see how tempting it is to get sort of, your legal and your commercial offices get drawn into sort of negotiating these financial terms, because any business person would want to have these things sort of arranged up front, and you then get sort of caught into kind of working out financial terms and upfront payments on work that in most cases doesn't result in anything of commercial value. And so there's an enormous waste of time sort of working out these terms and conditions. And it's one of the reasons why I think IP clauses and IP and research contracts sort of become sort of a big issue and chews up a lot of time, and it's really a lot of wasted time. And my argument is that it's better to spend that time sort of focusing on what's being done and getting a clear statement of work than getting the IP terms crystal clear. I also just included something on university licensing results in 2012 that includes the Canadian data. So whereas the U.S. had 2.6 billion in licensing income in 2012, in Canada it was about $67 million. So if you take the sort of 10% rule of thumb, we're in Canada lower than the U.S. in terms of, we're not 10% of the U.S. in terms of licensing income, although the growth numbers in terms of licensing income is greater than the U.S. If you look at running royalties, or sorry, cashed in equity, we didn't have data on running royalties. The equity cashed in from U.S. companies was $64 million last year, or 2 years ago, I guess now. In Canada, it was about $5 million, but there was looks like a great growth factor in the previous year. So typically Canada does less well in terms of those indicators than the U.S., although it's got greater growth year over year than in the U.S.
But isn't that because there's the difference in structures? Like if you were to compare the government or the public schools to Canadian schools, I'm sure the numbers would look a little bit different.
I think one factor would be the length of existence of tech transfer offices and investment made in patenting. In the U.S., they've been investing significantly since 1980 in the Bayh-Dole Act, whereas in Canada, there's about a 10-year lag in universities getting involved in this sort of activity. In fact, some universities are just getting involved now in it. So that's probably one factor why the numbers are greater in the U.S. They've just been at it longer. And given the long timelines of revenue in commercialization of IP and just patenting, that time factor probably matters a fair bit. So I'm not sure. I'm pretty sure I'd say that it has nothing to do with the quality of the research work or the quality of the institutions. It's really more about the commercial context.
I think where I was getting at is more the eye towards the business and the licensing models, right? So you often see the Gatorade University of Florida example cited, right? And so as a for-profit institution, their mind is on, hey, how do I capitalize on this this innovation and the licensing of that? Whereas in the Canadian universities, they don't always have that mindset when you're talking.
Yeah, could be. There's a whole, as you probably know, there's lots of literature that recently has sprouted up on sort of trying to explain why that difference exists, and especially the Canadian Council of Academies has had a number of reports on sort of what are those factors. And, yeah, so it's an interesting debate. Yes?
Do you have any details on what percentage of that figure represents Canadian companies that have been recipients, and also small enterprises versus large? Is there any information?
There is data on that, but that wasn't part of this data. This was just university licensing income. What's your question?
So, of that 65.9 million, how many were Canadian companies that were exploiting the results of the IP, and how many were SMEs versus larger?
Yeah, I don't know the answer to that based on this data, but I do know that it's 90% plus Canadian companies are exploiting that and generating that licensed income. And I don't know, but I would suspect that most are SMEs. Yeah. Okay, so the approach that is in the draft Mobile First Collaborative Research Agreement is a little different than what sort of the Canadian norms are, in that it's drafted to talk about sort of exclusive market commercialization and then residual market commercialization. So the concept is that the parties to that agreement will have certain areas of access to the results of the work, and that there would be then sort of a residual area of IP that would be not exclusive to any one party. So it looks like the approach is to try and sort of in advance divide certain market segments up. So sponsoring parties would have certain rights in those market segments, and that there would be another area that would be sort of open space, that would be residual, not proprietary to any one company. And that there would be IP protection by a partner within that exclusive market commercialization zone. So it's I think what it's seeking to do is try and pre-negotiate sort of what those fields of use are in licensing language, in order to avoid having to sort of define those after the fact, once there's some result developed. It talks about also the open exchange of information regarding all exploitation of results, and it has the usual sort of language about publication of research results by the college. The challenge, I think, I'm just giving sort of some broad comments here. I haven't seen a description of what those exclusive market commercialization, what they are defined to mean, nor what residual market commercialization means. I think like in licensing and defining fields of use, the challenge is always sort of describing something now that's going to make sense in 6 months or a year or a couple of years, because things change and what you thought was a very clear market definition is different. And it's especially challenging for IP protection because IP doesn't necessarily respect market boundaries. You can have a piece of an invention that has application in a number of exclusive markets. And I think that'll be one of the, not insurmountable, but one of the drafting challenges that will exist in clarifying what those sort of zones of exclusivity are in this agreement. Okay, any questions about IP and research agreements before I move on to changing ideas of research? So I think statements of work in industry-sponsored research agreements present greater challenges than IP clauses because you're aligning sort of technical and scientific and sort of business worlds, which aren't easy. And in my experience, misunderstandings are very common, especially over milestones and deliverables. Lots more legal disputes arise over statements of work and what was to be done than over IP clauses. And so it's really important to define what will be done and how you're going to measure what will be done, and to try and ground the research in, I'd argue, industry context and user experience when you're doing industry-sponsored research consortium work. And important also to have frequent communication. So for for some of the projects at UNB that we, when I was there, were doing, if it was a big project, we'd meet weekly with the sponsors, which seems incredibly often. That's time-consuming to meet weekly, but in order to avoid sort of a separation of understandings about what was happening, we would, in those cases, have very frequent get-togethers to make sure we were aligned. And I think the dominant framework that we still have for understanding sort of industry-sponsored research projects is what's called the linear model of innovation. And the model is that innovation sort of happens on a left to right sort of program, beginning with basic research and then applied research, followed by development, and then production and diffusion. And it's been a highly influential model. I think it's been the dominant model for most of the 20th century in thinking about R&D. And it's so interesting that in the scholarly literature, the view is that it's dead. It's been dead since the 80s. That no one really believes that innovation happens this way. That it's sort of it was just a marriage of engineers and scientists back in the 20s that somehow persisted through the 20th century. But I really wonder if and what's so interesting is that within the scholarly literature, that's the dominant view. But if you're in government funding programs, whether in Canada and the US, I still think the dominant way of looking at the world is in the linear model. You think of NSERC funding programs or the US Small Business Innovation and Research Program, very much stepwise, kind of linear the way it's laid out. And this is just an example of, this is the UBC sort of innovation model that they had on their website a number of years ago, which replicates the linear model of innovation in terms of basic research and followed by applied research and development. The idea is if you pump enough money into basic research, good things will come out the other end of the pipeline. And that's how you sort of support your innovation system. And I think what's happening is, even now that the word is kind of leaking out that that scholarly thinking is that the linear model doesn't work, you're getting groups that are sort of reconfiguring their programs to make it look like it's not linear, but it's still pretty linear. So this is the new UBC model. But if you follow, so if you go from research to development to marketing to licensing, you stretch it out and it looks still linear. I think they're just kind of, they know that the word's out and they've got to make it look cool. it's in every sector. Like this is the pharmaceutical sector from Roche. This is another linear model of how innovation works. And even in the sort of trendiest areas of innovation scholarship, it still looks kind of linear. So this is something from MIT Sloan Management Review article that talked about the move from the closed innovation model, again, sort of going from research to development, to the new, sexy, open innovation model where you collaborate with universities and colleges and users and all sorts of good things. But again, the same idea. It's just sort of a linear process. And even for, some of you are familiar with technology readiness levels, and some government agencies insist upon defining yourselves in terms of TRL levels and where you're going to go from TRL 5 to 6 in their program. Again, very much sort of a linear kind of concept. Basic principles, step 1. Applied research, step 2 and 3, and so on, so you get to a mission-proven system.
Sorry, can I comment?
Yeah.
Sorry, just with respect to the linear model before, so I think that there's a couple of things. So one, it's in most circles of government, at least the ones I'm speaking with in federal level, the decision makers actually know that it's not linear,
Okay.
right? That it's not research to market. However, what this is a selling point for a lot of, for anybody who's putting in an application to answer is what's the economic benefit of this research, right? And so I think that that's one of the reasons why you see a lot of this, here's the input, therefore here's the output type of thing, because it's a selling point for funding.
Mm.
But I mean, people aren't that naive.
Yeah. Yeah. Although I still think there's something to the linear model. I kind of still a believer.
I think that there's basically curiosity-based research, right?
Yeah.
Where you know at least you've gone down this path. That path doesn't lead to anything. Okay, everybody now knows that that's not something that should be investigated. So there's a lot of research where there is no outcome because it wasn't meant to be outcome-based.
Yeah.
Right?
Yeah.
And we're actually evolving more towards a hybrid. So before we were primarily basically curiosity-based, research-driven. I think one of the things I'm seeing is that it's evolving. There's a little bit more directed type of research in certain areas.
Yeah. Is there a comment over here as well? Thank you for that. I think that the new normal science of innovation studies has moved from the linear model of innovation to new models of innovation. User innovation is sort of a popular topic, and then something called Mode 2. I'll talk a little bit about that. It's sort of the new model that people talk about, and it's the sort of normal science in especially European business programs, business schools, less so in American MBA programs. So user innovation more popular in U.S. business schools, Mode 2 more popular in European business schools. User innovation talks about and it's so interesting because it's not just in business schools, but social science departments, humanities departments, history departments all sort of have their own little view on user innovation. Simply put, it talks about the importance of users in innovation and in R&D, and so been lots of discussion today about the involvement of users in the design of the work that you do. The Mode 2 idea is that there's a distinction between sort of the old kind of research work that was disciplinary, lab-based, focused on disciplinary theories, you communicate to your disciplinary colleagues, and then what's happened from sometime after World War II is there's been a move to this Mode 2. They're not very good at names. It's Mode 1 and Mode 2. And in Mode 2, you've got, there's all the buzzwords. They've got new knowledge produced through socially distributed, application-oriented, transdisciplinary projects, subject to multiple accountabilities, done in the context of application. So that's the sort of the big concept, and it comes out of policy work, not historians or people who are sort of doing normative research. It's really more sort of a concept, but it's captured the imagination of a lot of scholars around the world. And it's interesting, both people who are highly critical of this concept and people who are boosters of it, both agree that there's something that's kind of changed in the university and college world in the last 50 years, that there's been this move, whether it's a good move or a bad move, there's disagreement about, but both the critics and the boosters agree that something's changed, and it's kind of like what's described here in this mode 1, mode 2 thing, which is interesting. And so in my dissertation work, I did a history of myoelectric systems from 45 to the present, myoelectric hands and elbows and arms and shoulders. And I asked whether it fits the mode 1, mode 2 thesis. And the answer was no, it didn't. That if anything, it sort of was almost reversed. That the people who were more design-oriented in the 60s were much more focused on users and making systems and working in hospitals and clinics, and that the people in the 90s and 2000s were much more oriented towards research work, more basic type research work, less focused on being in the hospital or in the clinic and just being self-identifying themselves as design engineers as opposed to researchers. So there was a few takeaways that I thought would be relevant for this workshop. One was one of the 6 commercial systems that exist for hands and electronic hands and elbows all came out of groups that, unlike most of the groups developing these systems, moved out of university and college labs into clinics and hospitals and were confronted on a daily basis with users and prosthetists and others involved in developing those systems. And it was not sort of, there was some reasons why that happened. And it was in this case, this is at the University of Edinburgh. They developed what's called the eye limb. It was the first hand with 5 functional fingers. You can see here, this is one of the digits with an individual motor in it. And really the research was driven in part because the inventor was in a clinic confronted by users. And he, for example, had this user who told him what he should be doing in designing this new system. And he drove him to sort of announce certain dates because he wanted the device by certain time periods. And so it was really sort of, I'm not sure he would have developed the hand if he had been somewhere else, if he hadn't been confronted by this context. And although I'm suspicious of the sort of mode 2 theory and didn't really work out that well in terms of describing the history of the 20th century electric hand business, the idea that you have to that it's important to be in the context of application if you're designing systems that are going to be used turned out to be very important, at least in this little area of research work. And what was so interesting about one of the 2 days I spent up at Edinburgh is I flew down to Southampton. Oh, this is just a shot of the Edinburgh Centre. So it's a clinic. It's got labs and it's got prosthetists and places for making systems. So you can see what it means to be sort of immersed in that environment and how it influences the design work that gets done. I flew down to Southampton to do another interview with a group that's developing the Southampton hand. And to take nothing away from the great work that they've been doing, they're in the 4th floor of an electrical engineering department at the University of Southampton. And they've been developing this hand since 1969, continually. And I asked them, have you ever fit a user with that hand? And they said, yeah, once, sometime, there was someone who took it to a hospital, but it had never progressed beyond a prototype. It had just been a 40-year sort of university project. And it was just so exemplary, the difference between sort of being in a context and what that did for the group, and then the other one that never left the electrical engineering department, just tinkered away in sort of university thesis and dissertation programs to develop the hand. It was even sort of more sharp in the case of UNB, and UNB sort of got ahead of the game in developing electric hands in the 60s, largely because this guy, Dr. Scott, moved himself from working just at UNB to the University or to Toronto and worked in the Macmillan Hospital there doing fittings. And because he was sort of engaged with patients and users, he found an approach to developing devices that got him sort of ahead of the pack, the rest of North America who was developing these devices back in the 60s. There was a 16-year-old girl who he was fitting with the device, and she refused to be fitted with the device. This was This is in the late 60s. The funding largely came as a result of the thalidomide crisis in 62. A number of groups in Canada got funding to develop hands. And it turned out that the thalidomide children didn't want to use the devices, these hands. They'd rather use their limbs. They had more feeling, more sensory with their limbs. But for people who are above elbow and below elbow amputees, the devices were quite useful. And in doing a fitting with the 16-year-old girl, the girl said, I don't want to wear this. I don't want to be fitted with it because it looks like pliers on wires. And this was a shock to the electrical engineers because they assumed that's what the user would want. And were sort of shocked that they didn't want that. They wanted something that wasn't bulky and difficult to use. They wanted something that looked like a natural limb and it wouldn't sort of stand out. And that design insight led UNB to sort of design limbs that had battery packs and electronics that would fit within what would be sort of a normal shaped limb. And that gave them a lead on the rest of the world in developing these devices and led to the growth of the Institute. So again, if they hadn't got themselves into the clinic, hadn't encountered this user and realized, had this sort of epiphany moment that, users matter. We have to sort of take their wishes into account. There wouldn't be that design approach that UNB sort of was able to exploit in developing this area of really design, not initially research work. The last group I'll talk about is the group that sort of reconceived of the research process as a design process. This is Stephen Jacobson, who's a real remarkable university researcher. He runs a design program at the University of Utah. He went to MIT and studied under a design engineer who developed the Boston arm. And when Dr. Jacobson went back to the University of Utah, developed the Utah arm. He's got over 300 patents and products. He's had a number of companies that have either gone public or been acquired. Like remarkable work for an entire university, let alone a single person. So sort of an outlier. But what was so interesting is they sort of took that user-oriented experience and really conceived of it as not really a research approach, but as a development approach, a sort of commercial development approach. Like really like I call it sort of a more stage gate development process as opposed to a typical university research process. I'm not, it's taking the university sort of, I'm surprised he still works at the University of Utah, but he really sort of reconceived of his work in the design center that works in all areas of science and technology as a commercial development group who develops products and begins with typical things you do within corporations, patent searching and literature scans, and going through a program to get products launched. So what does all of this mean for statements of work and research programs? I guess my view is that supply and sort of demand sides are important, and although my colleagues don't like the linear model of innovation, I'm still sympathetic to it. I guess I saw it in my little dissertation. There was lots of prior work that was done that was very basic work. It was critical to developing these devices, and so I still I'm a great believer in the importance of basic research and the value that has, even in very applied projects. And so I think not orienting work towards that kind of literature, prior art searches, or even doing that kind of work is a policy mistake. But I think when you're looking to develop work that's useful, certainly engaging with users and getting yourself into the context of application can have benefits. And that's not just sort of for bioelectric limbs, it's sort of in all areas is the current thinking within innovation models. And so statements of work are really sort of incredibly difficult but incredibly interesting to do. It's one thing to develop a great sort of research program that is just research for itself, but that's challenging. But I think it's really interesting to then sort of bring another world into that program and try and make it, merge those two worlds. It's a very interesting, intellectually challenging thing to do. I think if you can do it, framing those statements of work in the context of feasibility studies and techno-economic models and business models is also very interesting to do. And I think if you can do that in the context of discussions with your colleagues in a number of sectors, it enriches that work. And certainly it's something that we do in our company. Now we're different than a university, of course, but the models really govern sort of our research programs that we do with other companies. And it's the milestones deliverables that we develop in light of the models that sort of provide us with our tests on whether we fail or succeed in our targets. And again, it's research work that we're doing still, so it's not like we're breaching contracts and failing to meet our milestones. We're just undertaking a research program, which we don't know what the end will be. And the benefit of having those clear pass or fail points is to sort of let us know whether we're in the context of our business model and our economic model or not. The last comment is like your description of fields of use or commercial markets, which are very typical in research contracts. We're also having to sort of renegotiate our statements of work because we find that after 6 months or a year, things have changed. Our understandings of what we thought the market conditions were not perfect. We thought that we had very clear ideas of what the pass-fail mechanism were going to be in the research contract. We now realize it isn't. So often we're renegotiating those arrangements, and that's where those weekly meetings or monthly meetings or relationships are very important, so that you can renegotiate those terms and modify them in light of what makes sense at the current time. I think that's it. So thank you for your attention. Are there any questions?
Any questions for David?
Bill?
I do. Yeah. So, do you have some examples of those statements of work or statements of work that follow those last principles that you talked about in that last slide? Or
Yeah, I can share those with you. Yes.
I take it you've been involved in drafting the draft of the MBCC agreement?
No, I haven't.
Oh, no, you haven't? Okay. So you don't know when that will be available?
I don't.
that I could mention. I think we expect that to be available probably in February, but we could probably show you the draft as well for input.
Yes.
Any insight on what we can do to drive more collaborative research agreements with the university? My perspective is that we have excellent programs available through INSERC and through even IRAP and CIRAP and other scenarios, MITAX, etc. Yet it's still somewhat underutilized and underappreciated, these possibilities. Any ideas as to how we can be more aggressive in exploiting these mechanisms?
New Brunswick overperforms the rest of North America on collaborative research agreements, surprisingly. I'm not sure why that is. One theory is because it's there isn't a lot of R&D workers in companies in New Brunswick, and so they engage universities and colleges more. So to some extent, the question is, what can other jurisdictions learn from New Brunswick, given that there is, on a per capita basis, more R&D being done in colleges and universities under CRAs. In Canada, it's the big initiatives have been, I guess our INSERC policy person isn't here, but the NCE program, CFI programs. So those are the ways that we've increased those R&D dollars. But I think what you're asking, William, is what can universities do differently too? Is that your question?
Say again?
Your question is, what can universities and colleges do differently to do
Well,
more?
what can we all do to increase the deal flow?
Good question. I'm not sure I know the answer to that. Any thoughts from the floor on that? Any question? I guess on just,
Well,
given that I talked about IP clauses, I think one of the things that you would want to do is have more flexibility on IP options and contractual terms. But I think one of the things you already have in Canada is you've already got great flexibility on that topic, as opposed to the U.S., which is much more focused on a single approach.
As you know, I myself, from our history, that I promote that and try to be very proactive in that regard. I find it still a very, very hard slog. We've been successful, but it's still very hard.
And what barriers do you see?
Lack of familiarity. I think too that perhaps some companies may dismiss the academic environments as being too theoretical and not focused on delivering results that are practical. Maybe there's an ivory tower sentiment to some degree in the academics environments. And I say all that maybe,
Yeah. I don't know. It strikes me more as sort of myths. If I think about just the morning in this room and the talk about the orientation that Catherine, you talked about, and then the tables talked about, it seemed very, very user oriented, very, very open to industry collaboration. So.
What sometimes puts some people in industry off is the tendency of some academics to have no problem. They want to make it a bigger problem than it actually is. So if somebody's got a specific question, then it's tempting to, as a researcher, to see all the infinite possibilities and the problem solvers and stuff. And then once it just becomes very long.
well, I've definitely had scenarios where they never really could. They couldn't nail down a practical issue because they were impractical. But I've had many other very good scenarios.
Yes.
There was a student academic research where students potentially could take their research and turn them into startup companies. What would you recommend or suggest would be the right time for students to PhD students or master's program become acquainted with the process of IP, conversion of IP? Should that be instructed in graduate schools or with prior academic knowledge of professors to supervise or should be
So it exists. It exists on in the Atlantic region and across Canada. There's offices like Springboard that are there to provide that advice. So I don't know that it needs to be built into the academic curriculum, given that it exists both within university offices like Springboard. It also resides in a lot of either professional or colleagues of yours. So one of the companies I work with at UNB is called Inversa Systems, that arose out of a PhD's research work in mechanical engineering. Developed a single-sided X-ray imaging system. And it's been 10 years. They've turned the corner on their revenue. They're now cash flow positive, and I think a combination of sort of using existing resources that are there to sort of help you with developing the company and patenting and all that sort of stuff, as well as existing or previous PhD students who have gone that path and developed companies would be a good way to start. And I know that the two heads of that company, and I would be happy to set up a coffee and introduce you. And I think it's the earlier the better in terms of starting that discussion with people who have done it before.
I would put a plug in for the software community to get that right in the first year, probably your first session. Right, it's a different environment about the reuse of components and the modularization of things. It's pretty important when you look at the variety of different licensing schemes that are out there.
Would you build it into the academic program?
I would.
Yeah.
I would, because when you see what happens on acquisitions of software companies, it's been really eye-opening for me in seeing how the due diligence that needs to be done as that new asset's brought in, just to make sure that all the licensing is done correctly. It's just the nature of the work. And if you're out there and thinking, hey, I can just borrow that routine from X, Y, and Z, you can get yourself into trouble very, very quickly. So employers and the like are also looking at, how do I make sure that those people that are coming in have a strong appreciation for, again, the variety of different licensing models that have come up.
Any other questions? Okay, thank you.
Thank you, David.